And that went over the court's duty to investigate. And that only arises when the party alleging misconduct makes an adequate showing of extrinsic influence to overcome the presumption of jury impartiality. A specific non-speculative impropriety has occurred which could have prejudiced the trial of the defendants. That is what they're required to show, non-speculative impropriety. A hearing is not held to afford a convicted defendant the opportunity to conduct a fishing expedition. That is right from the United States Supreme Court in the 1983 decision.
A bit of an overstatement to say all 12 of them or 9 of them refused to talk to us. A few did.
9 refused, 3 agreed, and spoke with Mr. Wilson. The state's, of course, first concern with that is that in approaching these 3 jurors, Mr. Wilson lied to them. He said he was there to interview them to find out what the trial teams had done wrong or could do better in the future. He also told them that it was a confidential interview.
We're not attempting to impeach the verdict. The second part of the rule provides a juror may testify on the question of whether extraneous prejudicial information was improperly brought to the juror's attention. The transcripts have not been authenticated beyond this affidavit, and as Ms. Dunikoski has correctly noted, that this is hearsay, but has not correctly. She has said it's hearsay, and it would be hearsay if we were submitting it under Rule 801 to prove that these jurors told us the truth. When I found out I was the only black, I was like, oh my God, now I'm laying in bed, can't sleep anymore because I felt like the weight of the whole black race was on my shoulder.